Good afternoon. This is my first Blue Bacon video, and he seems like a decent fella. I'm not terribly impressed with his research skills, but he seems like a decent fella. I'll watch the video with you, and we'll stop it from time to time. But let's start here. This is 18 USC 795. 18 USC 795. I think he has it correct on here. Yeah, he does. Whenever, in the interests of national defense, the president defines certain vital military and naval installations or equipment. Remember that, installations or equipment. Whenever the president defines certain vital military and naval installations or equipment as requiring protection against the general dissemination of information relative thereto, it shall be unlawful to make any photograph, sketch, picture, drawing, map, or graphical representation of such vital military and naval installations or equipment. Installations or equipment. That's twice now. Installations or equipment. Without first obtaining permission of the commanding officer of the installations or equipment. Oh, wait, no, it doesn't say that, does it? It says of the military or naval post, camp, or station, or naval vessels, military and naval aircraft, and any separate military or naval command concerned or higher authority, and promptly submitting the product obtained to such commanding officer or higher authority for censorship or other such action as he may deem necessary. These are the canons of construction. These are the things that you need to understand to properly interpret a statute. First of all, you got to read the entire statute. That's step one. Step two is the ordinary meaning canon. Words are to be understood in their ordinary everyday meaning unless the context indicates they bear a technical sense. The conduct indicates that it bears a technical sense because they're distinguishing installations or equipment from the commanding officer of the doesn't say installations or equipment. So they seem to be talking about two different things. And then there's the presumption of consistent usage. A word or phrase is presumed to bear the same meaning throughout a text. A material variation in terms suggests a variation in meaning. Because they did not say the commanding officer of the installations or equipment, they must mean something different by installations or equipment from commanding officer of the military or naval post, camp, or station. And then there's also surplusage canon. If possible, every word and provision is to be given effect. None should be ignored. None should be needlessly given an interpretation that causes it to duplicate another provision or to have no consequence. So you can't say because they are using installations and equipment in this part and they don't use it in this part, well, it must mean the same thing as these other things. You can't do that. With that in mind, let's start listening. Well, I might need to turn him up a bit, maybe. Let's see if you can hear him.
President as requiring protection from the general dissemination of information. But that raises the question, what bases has the president declared protected? It's all in Executive Order 10104, which was issued by President Truman on February 1st, 1950.
10104. Awesome. All right. So again, we're going to interpret it with the contextual canons and semantic canons. All right? Whenever, in the interest of national defense, the president defines certain vital military, naval installations or equipment as requiring protection against the general dissemination of information relative thereto. So we know it's talking about information. It shall be unlawful to make any photograph, sketch, picture, drawing, map, or graphical representation of such vital military and naval installations or equipment without first obtaining permission of the commanding officer of the military naval post, camp, or station, or naval vessels, military and naval aircraft, and any separate military or naval command centered or on higher authority and promptly submitting blah, 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 right? I was reading the wrong part. Anyway. Okay. So, now, therefore, by virtue of the authority vested in me by the foregoing statutory provisions and in the interest of national defense, I hereby define the following as vital military naval installations or equipment. Again, the same word, requiring protection against the general dissemination of information relative thereto. So it's talking about information. Installations or equipment, talking about information. Number one, all military, naval, or Air Force installations and equipment, which are now classified, designated, or marked under the authority or at the direction of the President, Secretary of Defense, Secretary of the Army, Secretary of the Navy, or the Secretary of the Air Force as top secret. I know it's hard to read in here. Secret, confidential, or restricted. And all military, naval, or Air Force installations and equipment, which may hereafter be so classified, designated, or marked with the approval or at the direction of the President, and located within. So the installations and equipment have to be located within something. And that something is any military, naval, or Air Force reservation, post, arsenal, proving ground, range, mine, field, camp, base, airfield, fort, yard, station, district, or area. Any defensive sea area hereto established by the executive order, not subsequently discontinued by executive order, and any defensive sea area hereinafter established under authority of Section 2152 of Title 18 of the USC. Any airspace reservation heretofore or hereafter established under the authority of Section 4 of the Air Commerce Act of 1926, except in the airspace reservation designated by Executive Order number 10092 of December 17, 1949. D, any naval harbor closed to foreign vessels. E, any area required for fleet purposes. F, any commercial establishment engaged in the development or manufacture of classified military or naval arms, munitions, equipment, designs, ships, aircraft, or vessels for the U.S. Army, Navy, or Air Force. All military, naval... Okay, so any of this stuff, all military, naval, or Air Force installations or equipment which have been classified. Now, another one of the canons, I don't remember which one it is, but it says that everything in this section, since these are subsections of number one, are only for number one. So number one deals with things located within these particular kinds of geographical boundaries, places on a map. Number two, all military, naval, or Air Force aircraft, weapons, ammunition, vehicles, ships, vessels, instruments, engines, manufacturing machinery, tools, devices, or any other equipment whatsoever in the possession of the Army, Navy, or Air Force, or in the course of experimentation, development, manufacture, or delivery for the Army, Navy, or Air Force, which are now classified, designated, or marked under the authority, blah, 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 top secret, secret, restricted, and all such articles, materials, or equipment which may hereafter be so classified, designated, or marked. So this is talking about just equipment. The equipment, if it's outside of the base, if the top secret, secret, classified, or restricted equipment is outside of the base, then you can't photograph it, theoretically. And number three, all official military, naval, or Air Force books, pamphlets, documents, reports, maps, charts, plans, designs, models, drawings, photographs, contracts, or specifications which are now marked under the authority or at the direction, top secret, blah, blah, blah. So you get the idea? So it has to be, for number one, it has to be located within a base. For number two, it has to be not a base, but it can be weapons, ammunition, ships, vehicles, vessels, instruments, engines, manufacturing, etc. Not bases. One says if it's number one, if it's an installation or equipment, it has to be located within a base. If it's number two, it has to be specific equipment, essentially. And if it's number three, it has to be charts, maps, documents, things like that. None of this allows for a base. If you're reading it using the canons of statutory construction, none of this allows a installation or equipment to be read as a military base. Now, I understand that in the common vernacular we refer to bases like Fort Bragg. We say that's a military installation. But if it's Fort Bragg, wouldn't it be a fort? If it's Beale Air Force Base, wouldn't it be a base? You see where I'm going? Camp David. Oh, that's a camp. We may call it a military installation, but they are specifically using installations and equipment as something different. It's like saying bones. Your bones have to be located within your body. That doesn't make your body a bone. It contains bones. Hopefully. Unless you're like a shark or something. I don't know.
That particular executive order states that any base that has been declared restricted, confidential, secret, or top secret.
It doesn't say any base that has been declared restricted, top secret, secret, or classified. It does not say that. It says any installation or equipment that has been designated top secret, secret, classified, or restricted. Words have meanings. And it's the sloppy use of language that gets people into trouble.
Requires the protection as listed in 18 U.S.C. 795. Executive Order 10104 also references 18 U.S.C. 797, which states that if you publish the photographs that you took of a military installation.
Military installation. See, here's 18 U.S.C. 797. Installation or equipment. Installation or equipment. Naval installations or equipment without first obtaining the permission of the commanding officer of the military or naval post, camp, or station. See, it doesn't say what he thinks it says. He read it with a different thought in his head. Instead of looking at the text critically, he read it with a thought in his head, how am I going to prove that you can't film a military base?
It's also a crime. If you find yourself outside of the military installation, you'll likely see signs that declare the base restricted. On those signs.
Restricted, yes. Access. You cannot access the base. Unauthorized entry is prohibited. It is restricted to access. It is trespassing you. All persons entering herein, so once you've entered, are liable to search. Photographing or making notes, drawings, maps, or graphic representations of this area or its activities are prohibited unless specially authorized by the commander. Well, good luck on that. Any such material found in the possession of unauthorized persons will be confiscated. Entry on joint base McLoose implies consent to breath, blood, alcohol test. So this is presumably all persons and vehicles here are liable to search. This is presumably that if you are making notes, drawings, or maps, they can search you and they can confiscate whatever they find on you. Outside of the base, he doesn't have control. He doesn't have control over what goes on outside the base. It is outside of his area of jurisdiction.
It doesn't always reference 18 U.S.C. 795. Sometimes it references the Internal Security Act of 1950. Technically, just saying that the base is restricted is enough for 18 U.S.C. 795, but that doesn't mean that the internal...
No, it doesn't. No, it doesn't. And that's pretty easy to prove. Let's see. I'm thinking we're here. 13... What are we doing? 13.526. Well, number one, let's before I go into that one, let's just remember that the outside of the base has already been photographed extensively. Everybody knows it exists. Google vans have photographed it. There's nothing you could see there that is secret, top secret, classified. You can see an area where access is restricted, but the information is not. And there's a difference. I don't know if you remember, I pointed out a little bit in, I think it was in the executive order. Dissemination of information. They're looking to stop the information. All the information on what the outside of the base looks like is out there. All the information on where the base is located is out there. So this is the Internal Security Act of 1950. I think he goes over it. But it talks about the ingress thereto and egress for removal of persons therefrom, etc. They have to, they can essentially, the military can, this authorizes the military to make rules about dealing with its property. So this was signed into law, I guess, not really law. It's an executive order. It was signed by Barack Obama in 2009, and this changes some things. Number one, it gets rid of restricted. Restricted is no longer a classification level. Whoops! Whoops! Oopsie! 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 Restricted isn't classified anymore. It's not a classification. Oops! I didn't do my homework. Oops! Information may be classified at one of the following three levels: top secret, secret, or confidential. Now there are some things that are still, that it acknowledges as restricted, and it was the restricted data category from the Secretary of Energy, blah, 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 and restricted data, formerly restricted data, shall be handled, protected, classified, downgraded, and declassified in conformity with the provisions of the Atomic Energy Act of 1954 as amended and regulations issued under this act. So if it was formerly restricted data, if it was restricted data, it's going to be changed to top secret, secret, classified, or unrestricted. So there you go. Sorry. Oops! And it's based on, this is the actual Code of Federal Regulations that the president was dealing with, that initially gave classification standards, but he changed it. So there you go. And then why'd I have this one up? Oh yeah, classified information means any information which has been deemed pursuant to Executive Order number 12356 of April 2nd, 1982, or successor orders. This is a successor order. So there you go.
Security Act of 1950 isn't also important. The 1950 Internal Security Act, which was also called the McCarran Act after Senator McCarran, which was its big sponsor, was created by the House Committee on Un-American Activities.
I never understand why people throw in all this nonsense information that has nothing to do with whether filming a military installation is legal or illegal. And yes, filming a military installation, if it is top secret, secret, or classified, is illegal. But that doesn't make a military base into a military installation, and that doesn't make restricted a classification anymore.
The act covered a lot of things. It made certain un-American activities illegal. For example, you're no longer allowed to picket a federal...
You're no longer allowed to picket a federal courthouse. Wrong answer! You got to read it. Again, it doesn't say you can't picket or parade. It says whoever with the intent of interfering with. So you have to have intent. You have to have the intent of interfering with, obstructing, or impeding the administration of justice, or with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty. You have to have intent to do one of those two things. You can picket. You can parade. You can do all those things. As long as you don't have the intent. You got to read it. You got to read it, dude. It's not a bright line rule. That would be patently absurd. It would be patently absurd. That if they're parading on a public sidewalk in front of the Supreme Court, they have a fucking right to do that. If there is going to be any infringement upon that right, it has to withstand strict scrutiny. There has to be a compelling government interest, and the administration of justice and prevention of influencing judges, jurors, witness. That is a compelling interest, and it has to be the least restrictive alternative, narrowly tailored, least restrictive alternative. They're not just going to straight up ban picketing or parading. I mean, come on. If you're telling me if the St. Patrick's Day parade happens to march in front of a federal courthouse, that's illegal? Dude.
Federal courthouse. The act also gave a lot of authority to military commanders, allowing them to make laws to protect the security of the installations that they control.
They don't make laws. They make policies. They make policies. The law is the Code of Federal Regulations. The Code of Federal Regulations allows enforcement of those policies and provides penalties for violating those policies. But those policies are for the base, for what's going on in the base. Or if it's on a ship that's out on the ocean, a Navy ship that's out on the ocean, then the captain of that ship can make policies for that ship. But it doesn't change whether or not you could take a picture on a sidewalk, dude.
President Truman did not like this act. In fact, he
Who cares?
vetoed it, claiming that it made a mockery of the Bill of Rights.
And if it was interpreted and enforced as you're doing it, absolutely it'd be a mockery.
However, both the House and the Senate overturned that veto. It turns out President Truman wasn't actually wrong when he said the act made a mockery of the Bill of Rights. Certain sections were removed for violating the Constitution, such as one part that made it illegal for members of the Communist Party to get passports. However,
Oh, this is just painful.
most of the bill still remains in effect, including Section 21, the part that gives authority to military commanders, essentially giving commanders authority over anyone on their installation.
On their installation! Bing, bing, bing! Winner, winner, chicken dinner! You got something right, dude. Congratulations.
That includes soldiers, civilians, anyone. Now you might be thinking,
On the base? Absolutely. If you're on that base, you are subject to the policies of that commander. It reduces your... You still have rights. They're just reduced somewhat while you're on that base.
think to yourself, well, as long as I'm not in the military installation, I'm fine. There's a fence line. I just don't go on the fence line. I'm okay.
And I agree with them. As long as you don't enter onto that property, as long as you don't enter onto what is conclusively federal property, you're absolutely fine.
Well, here's where it gets spicy.
I like spicy.
Federal property often extends past that fence line.
Oh no! Oh no!
Not good. You may be thinking
Not good. Ugh. Oh, he's gonna set us up for the kill shot here.
to yourself, this man is full of baloney. How
You are full of baloney.
dare he tell me that you can limit the First Amendment? It's the first.
Well, no, I'm not going to go there. This is US v. Grace. We've gone over this before, or at least we have on my channel, several times. So they're talking about the Supreme Court, the grounds of the Supreme Court actually encompass the sidewalks. It actually encompasses the sidewalks that border the street. Congress made a law that restricted certain free speech activities on Supreme Court grounds. And the Supreme Court said in US v. Grace that it is unconstitutional to do this. Congress probably could have regulated everything from the sidewalks, from the outside sidewalks that border the street in, but they can't regulate those public sidewalks. The prohibitions imposed by Section 13K technically cover the entire grounds of the Supreme Court as defined in 40 U.S.C. Section 13P. That section describes the court grounds as extending to the curb of each of the four streets enclosing the block on which the building is located. Included within this small geographical area, therefore, are not only the building, the plaza, and the surrounding promenade, lawn area, and steps, but also the sidewalks. The sidewalks comprising the outer boundaries of the court grounds are indistinguishable from any other sidewalks in Washington, D.C., and we can discern no reason why they should be treated any differently. Sidewalks are, of course, among those areas of public property that traditionally have been held open to the public for expressive activities, and are clearly within those areas of public property that may be considered, generally without further inquiry, to be public forum property. In this respect, the case differs from Greer v. Spock, Supra Greer v. Spock. In Greer v. Spock, the streets and sidewalks at issue were located within an enclosed military reservation. Wait. Reservation. And were thus separated from the streets and sidewalks of any municipality. This is not true of the sidewalks surrounding the court. There's no separation, no fence, no indication whatever to a person stepping from the street to the curb and sidewalks that serve as a perimeter of the court grounds. They have entered some special type of enclave. In USPS v. Greenberg Civic Associations, we stated that Congress may not, by its own ipse dixit, destroy the public forum status of the streets and parks, which have historically been public forums. The inclusion of the public sidewalks within the scope of 13K's prohibition, however, results in the destruction of public forum status, and that is at least presumptively impermissible. But a boom! Traditional public forum property occupies a special position in terms of First Amendment protection and will not lose its historically recognized character for the reason that it abuts government property that has been dedicated to use other than as a forum for public expression. Nor may the government transform the character of the property by the expedient of including it within the statutory definition of what might be considered a non-public forum parcel of property. The public sidewalks forming the perimeter of the Supreme Court grounds or any fucking military base, in our view, are public forums and should be treated as such for First Amendment purposes. Suck it. Suck it.
First Amendment is the very first one. That means it's most important.
It is the most important. That's why I could tell you to suck it.
Well, actually, there are a lot of things that limit your First Amendment right. For example, you can't yell fire in a public building.
The court used that as an example. That would technically be dicta. The case in front of that court was not someone yelling fire in a public theater. So maybe not. Technically, it's dicta.
That's a limitation on your right to free speech. You can't stay in a public park with your friends after it closes. That's a limitation on your freedom of assembly. You can't sacrifice babies in the name of your religion. That's a limitation on your First Amendment right to freedom of religion. And you can't film a military installation.
You can film a military installation if it is not classified top secret, or classified top secret or secret, yeah. And you have impermissibly equated a military base with a military installation.
That's a limitation on your freedom of press.
No, it is not a limitation on your freedom of press, because number one, it doesn't exist. And number two, well, I have yet to see any court case holding it to be so.
All of those limitations have been determined to be reasonable, which is why they're allowed.
No. The limitation that you have just suggested, that filming a military base can be prohibited from public property, from a traditional public forum, from off base, has not been held to be a reasonable restriction. So the test is, in a traditional public forum, or in a traditional public forum, if it is a time, place, or manner restriction, if you could say you can't film this particular place on the public forum, right, then that would be subject to intermediate scrutiny at best. And the government has to have a significant or important interest. Filming the outside of a base is not a significant or important interest. They have been filmed. You could probably buy a fucking postcard of the front gates to a base. And it has to be narrowly tailored, and it has to leave open ample means of alternative communication. But the important thing is, it's not a significant or important government interest. The government doesn't have an interest in it has a very insignificant interest in its gates being filmed. That's why the government has allowed Google vans to take photos of the front entryways of those bases.
If you really want to film the base, contact them. They can give you everything you need to know. In fact, they might let you film without any problems. Some bases will let you film anywhere that's not an access control point from the outside. Some bases let you film.
Some bases will allow you to film anything that's not a classified, secret, or top secret category. Oh, I'm done. Anyway, so I know he's doing a thing right now. Filming is restricted. Military installation is illegal. Changed my mind. I hope I've changed your mind. If I haven't, well, it sucks to be you. Thanks for watching. Have a great day.